When most people think of estate planning, they tend to think of wills and succession planning, the transfer of assets from one generation to the next. But what most people don't tend to think about is their own protection. As medical science helps us live longer and longer, our physical bodies are beginning to outpace our mental capabilities. And so it's not uncommon for many individuals to face the challenges of dementia and Alzheimer's and those types of mental diseases that will attack the mind as opposed to the body. And when that occurs, if prior planning has not taken place, the only answer at that point is guardianship. And through a guardianship, the courts would appoint someone to make both decisions on financial aspects and physical aspects of the individual. However, guardianship is mostly avoidable and can be done so with two very simple documents. The first is a durable power of attorney, and the second is a designation of healthcare surrogate. That's what it's called in Florida. In other states, it can also be known as a power of attorney for healthcare or healthcare proxy. With these two documents, you've already appointed someone to manage your finances for you. You've also named someone to make healthcare decisions for you. With those documents, as I mentioned, guardianship can be avoided. However, there are certain circumstances under which it cannot be avoided. The first is if the individual becomes a danger to themselves or others. Most common is to themselves, such as in the case of you've got a dementia patient who lives at home. They'll maybe leave the stove on or wander and will not accept help. Unfortunately, under that circumstance, you kind of have to force help on the individual to protect them from themselves, and so guardianship must be used. Probably the more common occurrence, especially in Florida, is as someone becomes more susceptible to suggestion, maybe a little mentally weaker. There are people that will prey on that. Now, this can be independent third parties, or it can be distant relations, where they come in and they'll start getting inappropriate gifts, things like that. Once again, we have to take the checkbook away from the individual to protect them from themselves and that third party. And so once again, we would need to appoint a guardian for that circumstance. However, the good news is you can choose who that guardian would be through a designation of pre-need guardian. And so that's the third document we will use to protect an individual for their lifetime. There are other ways to protect an individual as well. A living trust can be a very nice tool for this purpose. Whereas powers of attorney are often used inappropriately, an individual may come in and have themselves appointed after somebody begins to lose capacity and revoke the previous powers of attorney. So that's very easy to do, and so it doesn't provide a lot of protection against third parties. However, with a trust, most people cannot amend a trust on their own and require an attorney to do so, and so a lot of times that can create additional protection for the individual's assets and remove the necessity of a guardianship, hopefully. Another possibility is that we can also assign a trust protector for the trust. And so this is an individual who keeps track of the trustee and monitors that. And so if an individual becomes incapacitated and a successor trustee takes over that trust, the trust protector is in a position to ensure that that successor trustee is only making decisions to the best interest of the beneficiary. That obviously has a lot of benefit to it because there's another person overseeing the protection of the individual's assets. And those are the primary things that we can do. I did want to mention about Florida Homestead. Homestead is very unique in Florida compared to other states. It's very protected by the Florida Constitution. And as long as certain things don't occur, it is a very nice tool for long-term care. If the individual ever needs to qualify for Medicaid, the homestead does not count against the individual. However, I have seen families trying to plan around that who either did or considered making some terrible mistakes. For instance, adding your children to your home. If this is not done for value, in other words, if they do not pay you for your interest in the home, that is actually considered a gift and can disqualify you for Medicaid. One other potential risk is transferring the home out of your own name. Once again, if you don't own your home, it's no longer Homestead, and if you transferred it for less than fair market value, it's a gift once again. Or if you sold it to your family, you've converted an exempt asset, your homestead, into a non-exempt asset, cash. So anytime you're considering doing something with your home to qualify for government benefits, it's very important that you consult with an attorney so that you do not make some very costly mistakes. So that's the kind of protection a good estate plan can provide you during your lifetime. Thank you.